You, Ingrid. My name is Kirk Monroe, and I'm with Brazosbin Guardianship Services, and I have been in the field of guardianship since 2004, and have been doing information sessions to families since 2005. And so we're excited to always have these opportunities, to talk with families about this topic of guardianship. Now, I always kind of make it clear up front that I am not an attorney. I am a Texas certified guardian. And part of what our agency does is we are actually appointed by the courts to serve as the legal guardian to incapacitated adults. And we are guardian to about 60 adults right now. And most of those are adults with intellectual developmental disabilities. And so have been through this process that some of you are thinking about many times, as far as from the perspective of being a guardian. So with that, we'll go ahead and get started. And what we'll do is I will present some information, then I'm going to stop and give you a chance to ask any questions. You can also always put them in the chat as well. But I will stop by a couple of times and give you a chance to ask questions. So with that, let me share my screen here. All right. Okay. And I've already made the disclaimer to you. Our goals for this session are we're going to talk about the guardianship process and the responsibilities of a guardian. We'll also talk some about alternatives to guardianship, and the paperwork that's going to be sent to you. There's actually a great summary of alternatives to guardianship from the ARC of Texas. And then there's also information on the supported decision-making agreement, which is an alternative to guardianship. And I will be touching on that a little bit today. So, and of course, we always want to make sure that we get your questions answered. I always like to point out some resources. And this is, if you go to our website, which is brazosbin.org, if you go to our resources page, you will find what's called a Texas Guide to Adult Guardianship. Now, this is in English and Spanish. Now, I will tell you though, the state, and this is put up, the state has not updated this since 2015. I keep hoping they're going to update soon. There's also the doctor's letter is there, a annual report. There's information on supported decision-making. There's also a list of guardianship attorneys, special needs trust attorneys. And then there's information on the Fort Bend County's Take Me Home database. I don't know how many of you are familiar with that, but I encourage you to check that out. This is something Fort Bend County started doing, I think a year and a half ago, maybe. And it gives you a place where you can, if your loved one does, if they do have some, disabilities, it allows you to list them in this database. And then if law enforcement ever picks them up, they run the names through this database and they will see if this individual has got a disability. And so it's a great tool there. So now I'm going to mention a little bit here about alternatives to guardianship, and then we'll talk a little bit more about it too later in the session. But understand that, Texas courts require that all alternatives to guardianship be considered first before deciding to pursue guardianship. And when we think of guardian or alternatives to guardianship, the ones that are most common are what we call powers of attorney. So that's your medical power of attorney and your durable power of attorney. Then there's the support decision-making agreement. There's money management, and by money management, we're meaning that if your loved one, chances are they'll start receiving like a federal benefit, like supplemental security income, SSI. When they start receiving that, you can be appointed by Social Security to like manage that benefit on their behalf. And so that's what we kind of mean by money management. So, and then of course there are trusts as well that can be set up, and those are seen as like alternatives to guardianship of the estate, so to speak. And I will talk a little bit more about that too here a little bit later on. So we're going to kind of dive into guardianship. And so the very common question that's often asked is, why do I need to consider guardianship or an alternative to guardianship? Well, understand that at 18, everyone becomes their own legal guardian, regardless of their level of functioning. And so this is why even biological parents have to look at possibly going through this process of becoming the guardian of their own child, is because when we turn 18, we all receive those civil rights and we become our own guardian. That at that point, it doesn't recognize that that the individual might have or does have a developmental disability, and so guardianship of a minor is solely based on age, but guardianship of someone 18 or older is based upon incapacity, and so that's the difference, and that is why. That's why parents have to, consider going through this process. Also, a school has to look to the adult student to make educational decisions. So if your child is receiving special ed services and you're participating in art meetings, when your child's approaching 18, the school is going to inform you that, once they turn 18, we have to look to them to make those adult decisions, their educational decisions. So just be aware of that. And then of course, doctors have to comply with HIPAA laws. So that's the other challenge that happens too when somebody turns 18, is that medical information sometimes can be a little more difficult to obtain. And then a doctor may not perform a non-emergency medical procedure if they feel the individual does not understand what's going to happen to them. And so let me emphasize here that if it's an emergency situation, there are provisions in the Health and Safety Code that allow the next of kin to make medical decisions. Here we're talking about a non-emergency medical condition that may require treatment, and there may be maybe there's 2 or 3 options for that treatment, but a doctor may not do that if they feel the individual is not going to understand what's happening to them. They may wait till there's a guardianship in place for that to happen. So it's just something to be aware of. All right, so guardianship is state law. So all of this we're going to be talking about today only applies to the state of Texas. And so some of the key terms, and you've already heard me mention some of them, is what is an incapacitated person? And so it's the Texas Estates Code is where you will find all of the laws pertaining to guardianship. And so we look at Texas State Section 1002 there that defines an incapacitated person as an adult who, because of physical or mental condition, is substantially unable to feed, clothe, or shelter himself or herself, to care for their physical health, or to manage their financial affairs. And so what's important to understand about this definition is that as a court judge is hearing a guardianship case, this is what is having to be proven to them. And this is what the attorneys are having to prove up in a guardianship hearing. The next word is ward. And I know that ward is a very kind of a cold and sterile term. And there's been a time or two during legislative sessions that they've tried to get that name changed to a little bit more, I guess, respectable term. But so far that has not happened. But when we say ward in guardianship, we're meaning that it's an incapacitated person who's been placed in the care, custody, and supervision of a guardian. During the guardianship application process, they're referred to as the proposed ward. And then, of course, guardian is a person or entity to whom the rights have been delegated on behalf of the ward. And so why do we have guardianship? Anyway, again, we will look at the Texas Estates Code to find the answer to that. And this is Texas Estates Code 1001, where it states that the purpose of guardianship is that a court may appoint a guardian with full authority over an incapacitated person, or may grant a guardian limited authority over an incapacitated person, as indicated by the incapacitated person's actual mental or physical limitations, and only as necessary to promote and protect the well-being of the person. So there's actually a couple of things we get from this definition here. We see that the main reason we have guardianship is to protect an individual. It's not to control them, but it is to help protect them. The other thing we get from this is that a guardian can be given full authority, or they can be given limited authority. So by full authority, we are meaning that the ward has all rights have been removed from that ward. But a limited authority means that that ward has retained at least one right to do something for themselves. And so if they retain one right, then it's considered a limited guardianship. And it's nice to know that there's that flexibility here, because sometimes you may be in a situation where your loved one, they may be higher functioning in some areas, but maybe they're just they just may not have the capacity to deal with making medical decisions, or they may not be able to handle money or something like that. Then if the doctor's letter is in agreement with this, then if they retain the right to do something for themselves, then it's considered a limited guardianship. And the guardianship can be set up that way to where they have that ability to keep that right. And then also know that if you are given full authority initially, that as time goes on, if maybe as they develop maybe a little bit more or learn more, and they are able to do something for themselves that maybe initially they weren't able to when the guardianship is established, you can modify the guardianship and give them that right back. So just be aware of that as well. Okay, so in Texas, we have what's called, there's two types of guardianship. We have what's guardian of the person and guardian of the estate. So guardian of the person is someone who's appointed by the court to take care of the physical well-being of a ward. So this means that allows you to make medical decisions, placement decisions, like where they're going to live. It allows you to make educational decisions if they're still in school. And this is, for parents who have a child with intellectual developmental disability, this is usually the only type of guardianship you're going to need, is to be a guardian of the person. Of course, a guardian of the estate is appointed to care for the ward's property. And but as I mentioned earlier, guardian of the state is not needed to manage a federal benefit like Social Security or SSI or Social Security, because you can be appointed as the rep payee for that. So, and the reason, or the thing I kind of like to point out here when we're talking about this is that if you decide you are going to maybe pursue guardianship, if you start calling attorneys, it's better to to let that attorney know that hey, I'm looking to become the guardian of the person for my soon-to-be or adult child with intellectual developmental disability. That way the attorney's office is better able to tell you maybe about the approximate cost. Because if you just call them up and say, hey, how much would you charge to do a guardianship? without asking a lot of questions, they're going to assume it's a guardian of the person in the state, and those are more costly to set up. I mean, they can range the guardian. If you have to get both guardian of the person and the state, you're looking at about anywhere from $3,000 to $5,000. Whereas a guardian of the person is closer to around 3,000. Well, I want to say 2,500 to 3,000. So, now guarding the person in state, that's, like I said, for families such as yours, that's usually not needed. And then a single guardian versus co-guardianship, that's what I mean by that is, can more than one person be appointed at the same time to serve in the role of guardian? The answer to that question is yes, but the law only allows a husband and wife to serve in the role as co-guardians. And now if the biological parents are divorced, they can both be appointed as co-guardians, but it has to be an amicable situation. But that's the only time, that's the only way co-guardians can happen, is it has to be a husband and wife. They would not, the law does not allow, at least at this time, the law does not allow, let's say, biological mom and an adult daughter to serve as co-guardians. It has to be, they have to be married, or it has to be husband and wife. So, all right. So the estates code does dictate and prioritize persons who are eligible to become guardians. And here is kind of, I'd like to point out to families that right now in the state of Texas, whether you're looking at becoming the guardian of your soon to be adult child with an IDD, or if you are becoming the guardian of your parent that has Alzheimer's, the process to obtain guardianship is the same. So just keep that in mind, especially as we start diving into a little bit more about the details of guardianship. And they don't always seem to make sense if it's for a child with IDD, but it makes sense if it's, if you're trying to become a guardian of like their parent, especially a lot of the due process that's involved in guardianship. So, but so the courts, they first look to say, okay, is there a spouse that might be able to serve as the guardian? There's not a spouse, and then they look at next to kin. So that's parents, grandparents, adult siblings. Now, if there's no family member willing or able to serve, then the court may appoint any disinterested person. I kind of refer to them as a third-party guardian. Our agency is a third-party guardian. In our case, all of the clients that we're guardian for, there's no family that's willing or qualified to be able to serve in that role for them. So that's why we are involved with them. Now, in order for a guardian to serve in the role as guardian, the courts have to make sure that you qualify. And so it's easier to talk about who's disqualified. So anybody under 18 cannot be a guardian. A person whose conduct is notoriously bad. I know that's kind of a broad statement there, but know that all potential guardians, including family guardians, will go through a criminal history check before they're appointed, or before they can be appointed. So an incapacitated person, a person who is a party or whose parent is a party to a lawsuit concerning or affecting the welfare of the proposed ward, a person indebted to the ward, then a person, corporation, or institution found unsuitable by the court. Okay, so we're going to talk. Well, I'll tell you what. Why don't I stop a minute? Is there any questions so far that I can answer? Do I need to put the chat?
You're more than welcome to unmute yourself and make a question, because so far we don't have any at the chat. And if I may start, I have a question, Kirk. Sure. You said, or you mentioned the types of guardianship. There's the person for the person and the estate. You say what we regularly need is the one for the person. when some parents say we have full guardianship of our 18-year-old son or 20, would that be like their whole thing, estate, person? That's the most common thing?
No, what that's meaning, if you'll go back to when I talked about the full guardianship versus limited guardianship.
Mm-hmm.
In fact, letters of guardianship will say if you have got full authority or limited authority.
Mm-hmm.
So by full authority, what that's meaning is that all the rights have been removed from the ward. And
Right.
so they have no rights. Whereas if it's limited, that means the ward has retained at least one right. Yeah.
All right. So it doesn't really have anything to do with the estate at that point. Like that is something different. Okay.
That's something.
Thank you. Anybody else would like to ask something?
Yes, Rob.
Kirk, I had a question regarding timing. I have a 17-year-old becoming an 18-year-old in 5-6 months, and our take on it is we need to get it done before her birthday.
Okay.
And so, are there magic dates we need to hit?
Okay, those are great questions. So the earliest an application can be filed is when they are 17 and a half. Now, the courts will not hear the case until she turns 18. But want to go ahead now, so the doctor's letter, though, that you have to get is only valid for 120 days or 4 months from the date that the doctor does the assessment. So you are going to want to wait until you're looking at about 17, what is that, half, then what is that? So about 4 months prior to her 18th birthday is when you would, now you could go ahead and maybe meet and retain an attorney, but that doctor's letter, like I said, is only good for 120 days.
Okay.
All right.
And they're attesting to the disability or the incapacity, correct?
Right. In fact, I'm about to bring it up, but there's actually, the doctor's letter is a form letter where the doctor has to answer specific questions about what the condition is, what the prognosis is, and what they can and cannot do for themselves.
Okay, thank you.
Sure.
All right. We have a couple more questions. So it's what is the lawsuit exemption divorced? Well, and she explains divorce with child who is 18 and graduated may go back and seek DISB status under custody. I don't understand that, but maybe you do.
Yeah, I'm not, let's see, what is the lawsuit exemption? Divorced with child who's 18 and graduated may go back and seek disability status.
Disability status, yeah.
So my daughter's 18 and graduating in May, so she has child support through May.
Okay.
But I believe I can extend that by changing her status under the divorce as once she reaches 18, so that support would continue. So
And that's
it's been recommended that she get that a guardianship be established. But what if we try and change the divorce documents for her status? Would that create a situation where I couldn't get guardianship at the same time?
And that's probably a legal question I'm not going to be able to really answer for you.
Okay.
So I would encourage you to probably, because you're looking at different types of attorneys that handle things. Your divorce, or that's some of this that's handled by family law attorneys, whereas guardianship by probate attorneys.
Okay.
But yeah, you'll want to check with the attorney to find out that information. Sorry,
Okay.
I'm not able to answer that one for you.
Can I add something too? We do have a class coming up about what parents should know in Texas about divorce. So you may want to go on, there may be some information for you in that training. So, and just like you said, you can seek out an attorney, but I mean, if you want to get a little bit of information that may help you guide when you talk to the attorney, certainly go on to our class and enroll in that class. It's coming up soon.
Where do I go on to?
You can go to our website and familyandfamilynetwork.org and go into events, and then you can click on the trainings, and it'll show you, and you just click on that and enroll.
You'll see the title of every class, and that's where you click and you enroll there very easily.
Thank you.
Call
You're
us if you have
welcome.
a question. Thank you.
Yes.
And then there's another question. Can you obtain a limited guardian for finances and medical, or just one area?
I mean, yes, you can obtain a limited guardianship for like both finances and medical. As I mentioned, just the doctor's letter's got to be in agreement with that. And you'll see what I mean, because I'm going to show you the doctor's letter here in a minute. Because the doctor has to go, there's like a list of functions. It's question number 5 on the doctor's letter, where they go through and say they can do this, they can't do this, they can, and so it would have to be indicated in those areas that they're, that you'd want her to retain the rights, that they're able to do those things for themselves. So, all right, let me.
I have a question, an additional part of that. If
Yeah.
this is an adult child,
Uh-huh.
well, an adult who is 30, oh gosh, 30, 36. I had to think about that. But anyway, who's working now, who does a lot of things independently. However, the finance area is a critical area that she's not able to handle. So it's not like a doctor, when you say a doctor's notation, or, her diagnosis was early on.
Okay. You see, like I said, on the doctor's letter or doctor's, it's also called certificate of medical examination.
Mhm.
The doctor said you'll see specific questions and they're like, can they enter into contracts? Can
Okay.
finances. So those, and if they check, they have to be checked no. But yeah, in fact, I'll go ahead and bring that up so you can see that.
Okay. All right. Thank you.
Sure. Let me get back to, so here, that was actually kind of the next part of this. We'll start now talking about the steps that you go through to obtain guardianship. And so, as I mentioned, here's the doctor's letter, or like I said, the CME, it's also called. And you will see on here, they fill out information here at the top, the doctor does. This right here, this I last examined the proposed award on, this is the date that that the court would count the 120 days from. So you're gonna, want to make sure that this is very recent. You couldn't put, if I saw them like back in January or February this year, it wouldn't be a valid letter. And then they need to check on here that all these should be checked. This should be checked yes. Now this one may be checked no, that the mental status exam was given. That's usually more for like dementia. But this, before the examination and for the proposed award, the communication with me would not be privileged. That's part of that, informing them that, I've got to share, this is going to be shared with other people. And they go through and indicate, they go through and what their physical diagnosis is, then their evaluation of their mental functioning. And, so keep in mind that this is, you'll see stuff on here that is talking about dementia and stuff as well. Then we'll go to the next page, and they talk about cognitive deficits. And And so here's the one I was talking about. It's this question number 5, ability to make responsible decisions. And so they have to go through, like, make complex business, managerial, and financial decisions, manage a personal bank account, safely operate a motor vehicle, vote in a public election, make decisions regarding marriage, administer their own medications on a daily basis. Now, attend to basic activities of daily living, or what we call ADLs. It's okay if these are checked yes, because I know some of those, that some are able to do some of those basic things, like pick out clothes to wear and put them on, maybe brush their teeth, stuff like that. So it's okay if these are checked yes. Now, then, like, being able to consent to medical and dental treatment to this point going forward, and psychological and psychiatric treatment. So, if you're looking at like a full guardianship, you're looking at then like almost all these, except maybe the ADLs, would be checked no. And if you're looking at a limited guardianship, that means some of the area in the area you want them to retain the right, it needs to be checked yes. And then you see the next question is all focused on developmental disability that the doctor has to answer. And then there's this section 2 here, this determination of intellectual disability. We call it DID for short. I'm sure many of you are probably, if you're in the Fort Bend County area anyway, I'm assuming that you're connected with Texana. At some point, and if you're on the interest list for the eventual home and community-based services, that's that program with a 10-year plus waiting list. At some point, Texana is going to, a psychologist is going to have your child come in for the completion of a disability, a DID, and they will complete that. And so this section's here for that to be completed. And then, of course, they have to answer this question about definition of incapacity, then the evaluation of capacity, whether it's total incapacity or a partial incapacity. And then they complete this here. And they even, like, do they have the ability to attend a court hearing, questions like that. So now the main thing with this doctor's letter is that it has to be signed by a licensed medical doctor. The nurse cannot sign this, nurse practitioner cannot sign this. It has to be licensed because they ask for the license number. And so just be aware of that. But know that this is the only piece of medical evidence that's used in a guardianship hearing, is this doctor's letter. You don't have to provide school records or anything like that. This is the only piece of medical evidence that's used. So let's get back to, you've retained an attorney. And you've now obtained the doctor's letter as well. And so the attorney is they're the ones that prepare the application. And then you have to sign that application in front of a notary. And then the attorney is going to file that application. They're also going to ask you and trying to find out, okay, so certain family members have to be given notice. If you have like one biological parent applying for guardianship, if the other biological parent is living and not signing up to be the co-guardian, then they have to be notified. They're usually served that this process is happening. If the proposed ward has any siblings that are 18 or older, they have to be notified. And usually the way the attorneys do that is they will give you like a waiver for for those adult siblings to sign, or they'll send it to them. And then then the attorney will let you know just after they meet with you and question you if there's anybody else that needs to be notified that you're applying to become the guardian. Then once the application is filed, one of the first things that happens is this is because of due process. The proposed ward is going to be served notice of the guardianship, and it's usually a constable coming to your home to serve them that notice. They don't have to read it, they don't have to sign for it, but the constable does have to deliver it to them only. And because they have to actually sign an affidavit that they have given that to them. Like I said, this is one of these steps that doesn't make a lot of sense for someone with IDD, but it makes more sense, if you have an elderly parent, you've got 4 or 5 of the adult children who are, one's maybe trying to become the guardian, they're fighting, then it makes a lot of sense about why some of this has to happen. But so if your loved one has a fear of people in uniforms, just be sure to tell your attorney that, so that way they can let them know that they can let the constable's office know that they need to come in plain clothes, so that way it won't be as alarming to them. So now, guardianship training and registration. A few years ago, the state of Texas decided that all guardians need to complete a training. And this is online. It is through the Texas Judicial Branch Certification Commission. And there's the link there on there, and it's in your materials as well that you'll get. But it's a pretty straightforward training, and the reason they started doing this is because the JBCC started kind of looking in. They went into counties and started looking at guardianship records, and they were seeing that there was like people not filing annual reports, they weren't filing annual accountings, and they felt like they needed to offer this training to make sure guardians understood their responsibilities. And so that's why you have to complete this training. And so you register for the training, and your attorney will tell you all this, so don't feel like you've got to remember all this, but your attorney will tell you this. But you'll take the training, you're going to register with your name and an email address, and when you get through with the training, it's not anything you have to take a test on or anything like that. But you'll complete the training, and then you're going to be emailed a certificate that you've completed the training, and you're going to have to email that certificate to your attorney because they have to file it with the court to show that it's been done. So and then the other thing is Texas a few years ago wanted to make sure that all guardianships in the state of Texas are registered in a database. Again, kind of like the reason we have the Fort Bend, Take Me Home database. It's that, if law enforcement pulls somebody over, they run the name and they see that, okay, well, they're in a guardianship, then, they know to maybe alert the guardian and stuff like that. So, but your attorney will tell you, I know sometimes the attorneys actually want to do the registration, but they'll let you know if you need to do it. But I think that's also when you register, that also what is prompting the criminal history check to be done at the same time on the potential guardian. So, okay, now, I was mentioning that there's a lot of due process in the guardianship process. And so all proposed wards are to be represented by counsel. And so the court is going to appoint an attorney ad litem to represent your son or daughter. And they will meet with them. And of course, they'll meet with you as well. But they will, their role in a guardianship case is to represent what the wishes are of the proposed ward. not what's in their best interest, but what their wishes are. And then it's okay if they're nonverbal or limited verbal. It's, you know, these ad items, they go through training to be an ad item, and so they're prepared, you know, to deal with or to know about IDD, as well as, you know, dementia and stuff like that. So just be aware of that. Now, once the attorney ad litem is met with proposed award, then your attorney, I mean, we refer to them as the applicant attorney. They're the ones representing the potential guardian. They are going to be the one to schedule the hearing with the court. In Fort Bend County, hearings are only on Mondays. And the courts in Fort Bend that hear guardianship are the county court of law judges. So they're the ones that have probate jurisdiction. And we have 6 of them in Fort Bend County. All but I think only one of those courts is doing hearings in person. I think it's court 2. I believe all the other courts are still doing their hearings virtually. Then, so at the hearing, you know, the applicant attorney kind of presents their case, prove it up, as I had mentioned earlier. And then the ad litem usually will ask maybe a few questions. And then the judge makes their ruling. And then there's a bond is set. Even in guardian of the person cases only, you have to post a bond. It can be anywhere, I'm going to say, from maybe $10 to $100. It depends on the court. This is a one-time cash bond that is paid, you know, to the court, and then your attorney is going to also have an oath for you to take before the county clerk, and then that's filed as well. So you have to post the bond, file the oath, and order your letters of guardianship at the end of the hearing. And then, like I said, your attorney will let you know about usually if you know you're already registered at this point, and so you probably shouldn't have to register again. But yeah, I know it seems a little silly to have to post a bond. It makes a lot of sense in guarding the state. You know, if you're being given the responsibility to manage a certain amount of money, it makes a lot of sense in the world. It makes no sense in guarding the person basis to me, but it's the law, and it's just a one-time cash bond, and that is a bond that, you know, if the guardianship closes at some point down the road, or if the board passes away, then the court releases that bond. So, all right. So I just wanted to share with you kind of what a guardianship letter looks like. This is one of ours, and so some things I like to point out on this letter are that on the 9th day of May 2016, Brazos Bend Guardianship Services, we were duly appointed like successor guardian of the person for Dominique Gonzalez, and then qualified on the 9th day. So that's the same day. Is your qualification day may wind up being a few days later. It all depends on when the judge signs the bond order. That's what sets your qualification date. So usually this first date is your appointment date. So that's the date of the hearing. Then you have the second date, it's your qualification date. The qualification date is the day you are going to want to remember, because you see down here, this letter expires on the 8th day of September 2023. Guardianship letters are only valid for 16 months. And the reason that the letters of guardianship have an expiration date is because, you know, once a court establishes a guardianship, they have a responsibility to oversee that guardianship. And in order for them to kind of keep tabs on things, the guardian is required to file an annual report every year. And so that is why it has expiration date. And I will go over the annual report here in just a little bit, but this, this letter of guardianship, and you'll see there's a staple up there in the corner. That's because the order is attached to it, and that's been signed. And then there's there is on these originals, there's like a county seal that's embossed down here in the corner, so you know that it's an original. I always encourage families, especially if a child's still in school, to probably get at least 3 letters of guardianship when you're ordering them. They're only $2 each, but you always will want to have, or if are both parents, you may want to get 4. But you'll always need to have an original with you. You want to give an original to the school, and you'll want to give an original to the doctor. Most other places that say they need it, they can usually make a copy. But you can always go to the county clerk's office and get another copy if you need to. They will only release letters of guardianship to the attorney or to the guardian. So, guardian's responsibilities. What do we have to do? Well, you gotta, you're gonna keep doing pretty much what you've been doing already the first 18 years. But just always know that when you become a legal guardian for someone over 18 or older, that you can only act with the authority that's been given to you in the order. And like I said earlier, most guardians are given full authority, but you determine, where they live. You provide care, supervision, and protection of the ward. You provide clothing, food, medical care. You include the ward in as much decision-making as they're capable to assist with. You have the power to consent to medical, psychiatric, and surgical treatment other than inpatient psychiatric commitment of the ward. So if you're dealing with mental health, just know that even as a guardian, you cannot commit someone to a long-term, you can't commit them long-term to behavioral, like hospital. That you can do it temporary for emergency, but you can't do it permanent, for long-term. There has to be a mental health commitment hearing for that. You have the power to arrange transport of the ward to an inpatient psychiatric, as I just mentioned. You have the power to establish a trust for the purpose of qualifying the ward for Medicaid. And you have the power to consent to the administration of psychoactive medications of wards under protective custody or under mental health commitments. Advocate. That's what you're going to do more than anything as a guardian. And you've been doing that, I'm sure, already. Advocating a lot to make sure your child has the services and all that they need. And then I mentioned the annual report. This is an annual report that describes the social, medical, and residential conditions of the ward. And that's going to be the next document I bring up for you. And you'll get a copy of this too tomorrow in your in the information you get. But so when you file an annual report, you're reporting on the previous 12 months. And so, that one we were looking at, what was that? I think it was May. I think it was May was the date. But we can use today as an example if you want to make it a little bit easier. So let's say your qualification day is today, which is August the 11th. So next year, when you file your annual report, your report's going to cover the period of August 11th, 2022 to August 11th, 2023. Now, and this is right here in here for you to remind you of that. But you fill out this information up here at the top, and then you fill all this out. Like I said, you're just keeping the court informed of kind of what's going on. And of course, you always have to list their address because they're checking them and see if they've moved or not. Because they moved to another county, if the ward moves to the county, you may have to transfer that guardianship to that county. Because only the court in a county that has probate jurisdiction is supposed to be overseeing the guardianship. And the answer to those other questions there, you see you're giving them information on what type of home they live in, how long they've been there. Courts 1 and 2 have these financial questions that you answer. You answer questions about their physical health, their mental health. There's questions on here too. Just be aware that they're going to ask like what doctors, how many times have they visited that doctor this past year? Have they seen a psychiatrist, dentist? So you'll just want to keep track of those things because you've got to report that information. As a guardian, I believe the living arrangements. You just answer all these questions, and you get down here to question 18. As a guardian of the person, you're gonna always check this first box. So do you have a cash bond on deposit with the court? And then you are going to check those 2 boxes there, and then you sign it, and you date it. And if there's 2, if both parents are guardians, one fills out here, the other parent fills out down here, and y'all both sign it. And then this is filed at the county clerk's office. This is all you have to do each year is complete and file this report. And it costs like $10 to file it, and it costs $2 for the judge's signature. And then you order new letters of guardianship. Now, you do not want to wait 16 months, though, even though that letter is good for 16 months. You want to file the annual report. You can't file it any earlier than the qualification day. So as I mentioned in the example, like if we use today as a qualification day, August 11th, next year when I file it, I cannot file it until August 12th or later. But you're going to want to file it pretty much within 30 days. Because you need to give the court time to review the annual report and make sure everything is correct. And before they issue new letters of guardianship, and you want to keep that way your current letters of guardianship won't expire before the new ones are issued. So that's why you want to make sure you get it. And I just encourage you to either, if it's close to your child's birthday, that's going to be easy for you to remember when you do the annual report. If it's not close to the birthday, then maybe see what major holiday is around the qualification day. And that also that's a good way to remember as well. And I never mind helping families do an annual report the first time if they have questions. Sometimes the attorneys will also offer to help you as well. And you can mail these in, or you can complete them, or you can take them in person. So I'm going to stop there. Ingrid, how are we with time?
I think we're already 2 minutes away from 1 o'clock, but
Yes.
We're about, I know that normally I told you I spend an hour and a half, and you see why.
yeah. Well,
Yeah.
what we can do, there's one question here in the chat that they put a little bit ago, and then we can you can finish, and we can limit some questions for some extra minutes. So if grandparent has guardianship of daughter's person, can daughter obtain guardianship of her son's person? Daughter married and her husband eventually died. Her parents did not legally remove guardianship. I'm not sure I
It's
got
a lot.
Uh-huh.
Yeah, is this guardianship, is this a minor or someone under 18, or is it
So whoever wrote the question, you can open up and just ask the question straight out so we can get more information, so we can kind of help you to answer that question.
Right, I think
Yes.
it was Wileen, if she's still,
Yeah,
if
she's
she'd like to.
well
Oh,
there.
daughter is 41, she's saying.
The daughter is 41. Okay.
Mhm.
Grandparent has guardianship of daughter's person. Well, so who's currently the guardian? That's what I'm.
The boy's mother
Uh-huh.
It has some learning disabilities, etc. And um, we obtained guardianship of this boy's mother at 18.
Oh.
We've never removed guardianship. She's since married, had a child, and her husband died. So I'm just wondering if we need to remove her guardianship before applying. Her disabilities are such that she's able to work
Uh-huh.
part-time. Can't handle money very well. But she's able to make a lot of decisions for herself and so on. But the boy is autistic. He's higher functioning, and someone will need to be his guardian, after I pass away. I'm grandma.
I see.
And I do a lot of the caretaking and, make a lot of decisions for him, but I have no legal guardianship over him.
And how old is he?
The boy is 12.
Oh, he's 12. Okay. All right. Well, so to answer the first part of your question, if I'm understanding it all right, in order to for someone to come out from under guardianship, I mean, yes, they can have their rights restored, but you would have to probably have her assessed by a doctor to say that she can now do these things that she wasn't able to do when she came under guardianship. Does that make sense? Yeah.
Well, would she have to be able to handle finances and
Correct.
so on and so forth?
Yes,
Okay.
yes. And so now do you have full guardianship, or is it a limited?
That was my question too.
It's guardianship of her person, not finances.
Well, so okay, so but it sounds like you probably have, but were all of her rights removed?
Well, whatever is involved with guardianship of her person, we just did it so that we could be a part of, for example, the medical decision. She fortunately chose someone that we thought was okay for her to marry. So we didn't interfere there, and we helped them all we could. But the husband has since passed away.
I see. Okay. Well,
And
maybe if she was allowed to marry, she might not. It may have been a limited guardianship, possibly.
okay.
You saw it was one of the. They have to indicate whether they can marry or not. But yeah, I would encourage you to. You're gonna have to talk with an attorney, but I would also talk with her doctor to see, does the doctor feel that she would be able to have her rights restored?
Mm.
Yeah.
Mhm. Okay. Well, she can do some things, but she wouldn't. The finances part, I guess, if it was all set up. For instance, I set up an ABLE account for my grandson.
Okay.
And that's just a matter of, making contributions and so on. And I do that for him. And then I have another daughter, and she also contributes to the ABLE account. The other daughter has 2 children of her own, and she really is not too much in the market of, becoming a guardian for my grandson.
Okay.
So if it's not his mother, it would have to be, another entity.
Yeah, and I do not know a lot about guardianship of minors, because he's only 12.
Okay.
So I'm sorry, I can't answer many questions there. Pretty much just guardianship of incapacitated.
Yeah.
So.
Well, yeah, and we have no guardianship of the 12-year-old at this moment in time. We're just looking to the future when he turns 18 as to what we need to do at that point. Our guardianship is just of his mother.
I see. Gotcha. Okay, so you're trying to think ahead if he's
yes,
need a guardian. So okay, all right.
Well, but if you have any more questions, put them, send us an email and we'll try to get those answers for you. But, okay. And I think we are definitely running out of time. Well, we've ran out of time. It's now 1:04. so we want to be a good steward of your time. So if you have any further questions and you want some more information, go ahead and send us an email. We will send that information out to Mr. Monroe, and we'll try to get your questions answered as soon as possible.
Yeah,
But
I was going to mention, and we do information sessions about once a month. And you can always go to our website and look look under services, and you'll find information sessions. And we're doing ours by Zoom, and we have one on August 25th. And like I said, that's about an hour and a half. And there's an attorney that helps me when I do those sessions. So
Oh, that's a great invitation. Thank you so much. Could we write in the chat the website where they can find these sessions?
yeah, we sure can. It is.
Great, thank you. Thank you, everybody. And sorry taking up a few more minutes, but it's always very important to discuss a lot of stuff when we're talking about guardianship. We
yes, I
always
think this
learn.
is so important for
Mhm.
everyone.
Mhm.
So what I'll do too is I'll add it on to the information that I'll be sending you guys after. I'll copy it and paste it so you'll have it and you can go back to it. And you know, if you want to go to the class, I'll even remind you of the date. What time is that? August 25th, and at what time?
6 p.m.
6 p.m.
Mhm.
Oh, that's a good time when everybody's relaxing at home.
Yeah.
Okay.
We try to be respectful. I mean, we realize a lot of parents work and it's hard for them to do stuff during the day. So
Right. And just know that you guys don't forget to go onto our website. There are many more classes and trainings available for you. And remember all of the opportunities for those who are not here. We do have some personal networking that is free. It's 3 classes, it's virtual. So if you're interested in that, let me know. And also if you want to meet with Mass Mutual, their special care team, that's free. You get 3 initial meetings with them. So again, I do appreciate and thank you so much, Mr. Monroe, for giving us so much information.
right.
And we would hope that we'd have another class with you soon.
Yeah.
Right.
Let me know when you're ready.
Okay, all right. And so
Thank you
everyone
so
else, I
much,
want to
everybody.
say thank you so much for attending today. If you have any other questions, don't forget you can email Christina and I at any time, and we will get any question answered for you. Have a wonderful evening, and we'll see you next time.
All right. Take care.
Bye.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.
Excellent. Thank you, guys.
You're welcome. Bye-bye.